I got an email from Betsy several months ago, and I thought it was just kind of a general solicitation. I get these things all the time, you know, present a proposal, maybe we'll invite you to come to our conference to speak, that sort of thing. And I had my finger on the button to delete it. And then I thought, wait a minute, let me read this again. And it was specific to me. It was sent to me by my name. It referenced my program in the body of the email. And she referenced herself as being a fellow North Carolinian. I said, maybe this is not general, maybe this is specific. So let me reply to this person that I've never heard of before, but I certainly had heard of Florida Coastal Law School, and see what happens. So I did reply, and I thanked her very much for inviting me. Really didn't think I would hear anything back, but I did. And then we had a phone call. And during the phone call, it began to become apparent to me that she was not asking me to try out for her symposium. And I said that to her. I said, Betsy, I get the feeling you're not asking me to submit something for you to review to see if you're going to ask me to come. Sounds like you're asking me to come. She said, oh yeah, I'm asking you to come. And I was so flattered by that. And she said, we're going to pay for you to come. And so my dean was extremely happy to hear that. And my wife is traveling with me, and we have been treated extremely well. We had a wonderful dinner last night. And I must say, the greatest gift that I have received from being a clinical professor in a law school is not the program that I wanted to start to serve the community. That's the reason I got involved. The gift has been my relationship and interaction with our law students. And I'm telling you, last night, we had some great interaction with your law students. How many law students are in the house, in the room right now? Let me just say, in case your professors neglect to tell you this, you are awesome. Yes. The professors in my school typically neglect to tell our students that. They make them in the first year feel like they are absolutely nothing, when they have come from a place where they have been the greatest in everything they've ever done, and all of a sudden they are second guessing that, as I did when I was in law school. We had beautiful conversation last night. Is Kristen in the room? Or she may be in the overflow.
I think she's next door.
Well, hey, Kristen is next door. We had a great conversation about her husband and her 4 children, and her military career and her husband's military career. We watched her eat multiple desserts when they came out, talking about the things that she didn't like and she thought were terrible, trying to dissuade us from taking that choice. And the carrot cake was her favorite. I learned all about Kevin, who may be in the next room too, and we learned that we have a great affinity with each other for tasting the bourbon. Rob also, I learned, has that. He's going to do the Bourbon Trail in Kentucky pretty soon. My son is about to do that, and I'm really pretty jealous about that. Katie was sitting beside me, just the sweetest thing in the world, and learned about her probably going to be going to Michigan. And I told my wife last night I have a horror story about a lawyer that went to Michigan that I did not tell Katie, and Katie, I'm not going to tell you that story either, but it's just a beautiful time for us to be together, and I'm most grateful. This is the most beautiful plaque I've ever seen. It has my name on it. It's not generic. It has my name on it. When I go back, I'm going to show all this stuff to the dean because it just raises my credibility. My name to be printed in the brochure beside all these awesome people, to have a beautiful glass plaque with my name on it. And when I left Wednesday, I had actually left my contract for the coming year that I have signed, but he has not yet signed, on his desk. And so if he has not signed that, he really is going to see all this stuff. So I appreciate all of the kindness that you have shown me. One thing I've heard from the first presentation from Robin and Robert is frustration. Did you law students hear that? Oh my gosh. Frustration with systems. And you are preparing yourselves to be involved with systems. And I did that. I prepared myself to be a lawyer in a system. When I started law school, I really didn't know why I went to law school, other than I felt led to go to law school. I went as a 36-year-old grown-up guy with a mortgage and married and 3 young children. God bless my wife for allowing me to do that. And really didn't understand what I wanted to do. And people would say, why are you doing this? Selling your house, quitting your job, moving your family. I said, I really don't know. The only thing I'm positive of is that I'm never going to practice criminal law. Well, guess what? That's about the only thing I've ever done. Frustrated, though, very early on working in a system that I didn't see tending very well to the needs of the people that were being brought into that system. So, I want to say this to you law students. Frustration can be a very good thing. If you are willing, as your dean stood up here and said this morning, if you are willing to be frustrated and do something about it. Lawyers need to be about not creating the problem, but solving the problem. So be creative and be proactive in the systems that you work in, and get frustrated and then do something about it. And so what I'm here to talk to you about today is something that we have done in Raleigh and through our clinic in our law school to do something about the tremendous frustration that I experienced as a criminal defense attorney working in the criminal system in general and the juvenile system in particular. So frustration can be a very good thing. Often in the juvenile delinquency court, I would approach the prosecutor who had been a classmate of mine, Mary Stansel. I love her to death. She now is working in the public defender's office in Raleigh, so I see her all the time. And she graduated 1 year ahead of me. We had taken all the children in the legal system courses together and had the same passions. She became a prosecutor in Harney County. I became a defense attorney, and so we saw each other in the courtroom all the time. Very often, and I have a mediator's heart. I was certified as a mediator immediately after coming out of law school. I have a mediator's heart. So what do I want to do, y'all? Do I want to fight? No. I'm a lover, not a fighter. I want to sit down and talk. And I would go to Mary quite often with my cases, and I would say, Mary, can't we sit down and talk? And bless her heart, she always said, if you can get my prosecuting witness to sit down with you, that would be awesome. Do you think they did? Absolutely not. I mean, and you know, probably pretty smart. I was the bad guy. And for my clients, it wouldn't be smart for me to allow them to sit and talk either, because they have a right to remain silent, and that's good, because everything they say can and will be used against them by the state of North Carolina in a court of law. And y'all, the state has all the resources, okay? So it's a heavy weight that's against them. A lot of frustration in that. After I got involved in restorative justice, and I want to make some distinctions for you, I began to understand why I was so frustrated. Because the system was only asking one set of questions. And let me try to make a distinction for you now between the way I see our traditional criminal justice system and the way it's designed to operate, and the way that I think it operates pretty well, and then the restorative system that I learned more about after we began to explore a better way or a different way to do things. And let me just boil the system down into three questions that I think are relevant. In the traditional system, I think the first question is probably what law was broken. We need to know what to charge. So what law was broken? Once we understand what law was broken, we have to say who did it. And that's what the trial and plea process is all about. What law was broken? Let's charge correctly. And then who did it? And then once we determine who did it through our due process and our traditional system, what do they deserve? Okay, three questions in the traditional system. What law was broken? Who did it? What do they deserve? And that's where the punishment comes in. That was frustrating to me, because to me that leaves a lot out. I saw people in the courtroom. But when we ask what law was broken, what that really means is the offense is not against the person. It's against who? It's against the state. So the offense was against the state of North Carolina, and the state of North Carolina took control of the case, and they prosecuted the case, and the victim was marginalized. And that led to a great inability for my client to understand how they had affected another human being. Therefore, it was very difficult for them to hold themselves accountable for their actions. And what happens when they don't hold themselves accountable for their actions, and they feel like the state has slapped them on the wrist and they walk out the door? What do? Do it again. They reoffend. And I would represent them over and over and over. And for a guy who was all grown up when I went back to law school and wanted to help people, as I hope all of you do, that is very frustrating. I want to empower people to be better and live better lives. I have been supported so tremendously in my life to do things that I want to do that I never thought I could do, and that's what I want to do as a lawyer. So when you can't do that in a system, that can be very frustrating. Okay? And in the juvenile system, so many of my clients were in a criminal system because of something they had done in school. And that is what we refer to these days as the school to prison pipeline. Kids are doing things in schools, they're being petitioned, arrested, and look, you don't even deal with this in Florida. In North Carolina, do you know what the age of majority is when you commit a crime and you're sent to the adult system? What age? 16. We're the only state in the country that doesn't have a mechanism for a 16 or 17-year-old who is charged in the adult system to be sent back and tried as a juvenile. The only state in the country. I am ashamed of that. But that's the reality that we deal with. So when a 16-year-old gets in a fight in school and gets arrested, they're in the adult system. Even if they're never convicted with a charge that stays on the permanent record, unless they can get lucky enough to get with somebody that can help them go through the morass of the expungement system in our state. So this is serious business and extremely frustrating. So we ought to be able to find better ways to deal with these kinds of things. So that was my level of frustration. Now, I discovered through a good friend of mine, his name is Tony Baker, and I'm going to read an email from him in just a moment to kind of give you the picture of where we have been able to go with some of these cases. Tony had experienced mediation in the criminal context in other parts of the world before he came to be a criminal law professor at Campbell. And he and I had a conversation. We met at a symposium one day, kind of like this. He knew I was in Bowie's Creek, right across the street from his law school practicing law. I knew he was teaching criminal law at Campbell. We sat down and had coffee and talked. And he said, "What is your passion?" I said, "I'm a criminal defense attorney, just became certified as a mediator." He said, "Well, that's interesting because I would like to have a clinic in the law school that mediates criminal cases." I said, "You're a criminal law professor, you don't know, you can't mediate criminal cases." I'm not sending my client to you because everything they say can and will be used against them in a court. He said, "I understand that, John. We have to find ways around that. And one way is we can create local rules that allow your clients to sit down in the context of mediation and anything they say cannot be used against them in a court of law." I said, "Oh, okay." And I just saw your face. That was my face. I thought, okay, didn't know you could do that. Let's do that. So we have done that. And that is a huge reason that we are able to do the things that we do today. Set of questions that restorative justice asked. Okay, traditional asked, what law was broken, who did it, what do they deserve? Restorative justice looks at the people and it says, who has been injured by this criminal act? That's a different question. Who has been injured? What are their injuries? What are they? And what are the most effective ways for us to address that harm? Okay? So the focus is not on the offender, the focus is where? It's on the human being that's been affected by it. So we have tried to create a program that allows us to bring people into that space to answer all of these questions. And I know the state has obligations. I'm not advocating that we do away with the system that we have. I'm advocating that we bring along some other processes such as restorative justice to kind of fill in the gaps and try to meet so many of the needs that our traditional system is simply not prepared to address because it's human beings that are sitting in that courtroom. And how many times, if any criminal defense or prosecutors in the room, how many times do you see the victim who is subpoenaed to come in to testify if the state needs to use them as that tool that day, sit there until lunchtime when you get a break, walk up to the prosecutor's table and say, "My name is John Smith, I'm here for this case, can you tell me what's going on?" And they say, "Oh, I am so sorry. That case was continued at the calendar call at 9 o'clock, and you'll need to come back in 30 days. And I watch people do that over and over and over. I participate in that system because I was the guy asking for the continuance so many times, right? Participated in that system. Let me do what my law school did when I was learning how to try a case. And I thought this was a little crazy when I first heard it. They said, we're not going to start with the opening statement. We're going to start by teaching you how to craft your closing statement. Well, and then I learned there's good reason for that, because you need to understand what you need to say in your closing, so then you understand the evidence you need to get in from start to finish. And actually, how do you need to preface your case in your opening statement? So let me move to the closing statement. And what I mean is, I'm just going to fast forward from this idea that we had in about 2001, 2002 of creating this clinic where people had a safe place to come in and admit wrongdoing and take responsibility and do something about the injury they had done, to the place that we got where it actually happened. So let me read this email to you from Tony Baker to his son, written on February 12, 2005, about a case that Tony and I and some of my students had mediated very recently before he wrote this email. And by the way, Betsy's been so nice to me, but she's about to pass me off to the law review people, and I'm not so convinced they're going to be as nice. Okay, they will be. Well, Katie, I think, will be. I don't know about the rest of them. We'll see. And I'm not an academic. I'm a practitioner. Always have been, always will be. But I'm going to try to write a good article for you. And I think this is going to be page 1. Dear Andrew, interesting mediation last night at the law school. First is a white kid, 14 in middle school, failed. Daddy's dead. Mama's handicapped and unemployed. And these stories are going to be familiar to you, Robin. Right? You hear them all the time. Lives with his little sister. Mama has had multiple deadbeat boyfriends that have beat her and made life miserable for the kids. Alcohol, drug problems throughout the family, though the kid seems clean and somewhat responsible. Lived with Mama's father, his grandfather, himself an unemployed alcoholic, until the last of a series of fistfights between Grandpa and the kid drove him out of his house. Lived in lots of places. Had a bad student who, surprised, not racist, exclamation point, but finds identity with a group of down and out white kids that love to hunt, fish, and use the N-word. Likes rap music and sports, especially basketball. And I want you to remember that because you're going to hear it again in just a second. Likes rap music and sports, especially basketball. Second is a black kid, 15 in high school, not a terrible student, no idea who his daddy is. In fact, his last name, Samoan sounding, was picked by his mother to fill in the birth certificate because she liked how it sounded. Harnett County, Harnett is where I live, very rural, poor county, by way of New York City fairly recently. Mama, a drug addict who is going to get it together one day. 5 kids, none with her. Kid goes from mama to grandmama who died, to great-grandmama who died, to uncle and aunt. Uncle left the aunt, who kept the 5 kids, and it was not her blood side. The uncle was the blood side. The aunt kept the 5 kids, bless her. Decided after 5 years that New York City was toxic for black poor families, to quote the postmodern sage Dr. Phil, you think? And moved to her ancestral Harnett County. Kid freaks out. You ain't in Queens no more. And finds himself regularly in fights, usually with white kids, usually involving the N-word. Likes rap music and sports, especially basketball. How did Tony know that? Because we got the kids together and they talked about it. So we began to find common ground. When you can help human beings make a human connection with each other, you can solve problems. If you cannot communicate, you can never get there. And fortunately in some regards, unfortunately in other regards, we have the barrier down the middle of the room in the courtroom that does not allow us to do that. And Robin is shaking her head because she knows this can work in child abuse and neglect cases as well. And we see it working. What are the odds of these kids meeting on some nameless field in some hard-scrabble southern county and pounding the heck out of each other? Overuse of the N-word, among other things. And by the way, Marquise was brought into the system because he had hit Kyle with his fist, with his necklace wrapped around it, and busted his mouth open, and he was charged with assault with a deadly weapon. You know what I'm going to say. Inflicting serious injury, which was a felony. What are the odds of them meeting over a mediation table? Because some hard-boiled but soft-hearted DA, and that's Mary Stansel, she loves that part, saw clearly the absolute futility of the court process in trying to reach these kids. What are the odds of them talking with each other, listening to each other, and finding meeting ground with each other, symbolized by handshakes and sincere apologies? What are the odds of them meeting together over a pizza dinner with their families? Well, it happened last night, and when they finished the face-to-face mediation, they said, "We are starving, where can we eat?" And we said, "You like pizza?" They said, "Yeah." So there's a pizza inn about 3 miles from here. The two families got up and went together and had dinner that night. This is not an unusual circumstance, folks, when you create a place for people to come in safely and talk. What are the odds of them prosecuting their shared interest in basketball by together being guests of the Campbell basketball program at a Fighting Camels doubleheader? And we are the Campbell Camels, by the way. I think we're the only camel mascot in the country. There's a good reason for that. And by the way, the colors are black and orange. Please take a picture of me and send it to the president of my university, because he puts a lot of stock in people from Campbell that wear orange ties. All right. Hey, Dr. Wallace. At a Fighting Camels doubleheader next Saturday, seats right behind the Campbell bench. No, it ain't world peace, but strange work I've been called to. That was Tony Baker talking about the case. Now, I want you to hear this, because this is every parent's dream for their child. And this is my heart for children in our community. Tony, to his son, says, "Your camera is in and waiting for you. Our prayer is that it is filled with wonders and that you bring out every one. Love as always, and your parents' sincere prayers in Christ for you, which is the best we have to give. Dad." I want every kid that's been in our system to get that message from their father. That's idealistic, but that's my dream. P.S., and he follows up a week later. Basketball game was very cool. Took the kids on a tour of campus. They asked a lot of questions about college, as though the notion was brand new in their heads and cool and growing. Really liked the college girls. Ate together. Very warm hugs between them at the end. Kyle, the white kid, said, "Take Marquise home first so I can see where he lives." No, it ain't world peace, but that was the case that we did, and that's not an unusual result. I want to show you about a 15-minute DVD, and what time am I off?
You've got about 20 minutes?
Okay.
25?
About a little bit shorter than a 15-minute DVD. And then I want to take whatever questions you have from me, and then I'll get off the stage, because Miriam is already getting nervous that I'm going to eat into her time. Although she did say she's going to shorten hers a little bit so the panel can go a little bit longer. So let's play this sucker.
I got notified that there was an altercation in the pods out back. At the time, I had no idea who was involved. It was just, there was a fight. They needed me to respond to their pods. When I got there, the school administration and teachers had already broken up the fight. They had the two girls separated in two different classrooms. I talked to each of the girls. I talked to witnesses that were involved to get information about what actually happened with the fight. Based off the information that I received and the disturbance that it caused in the hallway, at that time I felt it was necessary to charge both of the girls with being involved in a fight. I called for another officer to come out and help me because I did not want to, my intentions were to place them both under arrest. I did not want to put them both in my car and have a risk of them fighting again in the backseat of my car. So I called another officer out to help me, and he transported them around, and I transported them around. Transported them to the Wake County Jail. They were both processed into the jail. Pictures were taken, fingerprints were taken, I assume. That's standard practice. They were asked some questions just to get demographics. The jail needed demographics for both of them. And I filled out the charges, presented it to the magistrate, told the magistrate what happened, and the magistrate at that time decided there was probable cause for the charges I had them charging them with. And then the magistrate, it's up to the magistrate to determine what sort of bond, if any, were placed on them. I had no idea what the bond was because I always leave before they were told what their bond is. The magistrate may have asked them both to post the bond. The magistrate may have let them sign themselves out or let the parents sign them out. I'm not sure. I'm sure they could advise you on that better than I can. And after that, that was all of my involvement on that day. I did not have any more involvement in the case until it actually went to court.
So what happened with these kids? Walk me through what happened. Yesterday I met two wonderful young ladies who just kind of lost it one day.
They did, yeah, Sienna and Tori.
Yeah.
And the way that this even came to my attention was I got a phone call one day from one of my previous students who'd been through our program, and she now works in the public defender's office. And she said, I've been assigned to defend a young lady who got in a pretty serious fight over at, well, she didn't say over at Broughton High School, but ultimately I learned it was over at Broughton High School. She said naturally she was arrested and I'm defending her. There's another co-defendant that somebody else is defending. And she said as soon as I looked at the facts of the case, I felt like this case doesn't need to be prosecuted. This case should go through the mediation process. And of course, since she'd been one of my students, she knew that the mediation process existed. A lot of the public defenders don't even know that it exists because we do operate mainly within the juvenile court system. And these young ladies were older than juveniles. They were 17 and 18 years old. So they were arrested and sent into the adult system, which happens when 16, 17, 18-year-old high school kids get in a fight and get arrested. They're in the adult system, which is much more serious as far as their record concerns and what their future, how their future is going to be impacted. So Charis Link was the public defender. She called me, told me about it. I said, well, I really appreciate you thinking about that. And she had already talked to the prosecutor in charge, and the prosecutor agreed that mediation would be a good thing because she was aware of our program in the juvenile court. And so they were agreeable to send it out. I said, the problem is we don't have local rules within the adult system to provide confidentiality, voluntariness, all the things that we're able to provide in the juvenile court. So I said, tell me where it happened. She said, well, it happened in school. I said, which school? She said, Broughton. I said, okay, we have an agreement with Broughton. And so we can provide the protections if it comes from Broughton. So I said, how about talk to the school resource officer that handled the case and see if he will send it as a referral from Broughton. And so that's exactly what happened.
I guess it was like over a boy, and then tension just rise from there, and it hit like skyrocket. It was
built up anger, I guess. So earlier that day, not earlier, right before fourth period, we got into like an argument outside, and I walked away from it and just like left it alone. And then towards the end of fourth period, I was outside in the hallway, and she came out of her class. Our classrooms were right next to each other, like right there next to each other. So when she came out, I saw her, and she went to the bathroom. So like I followed her to the bathroom, not to fight her, just to like talk to her about it, because I didn't want to wait to get into the bus loop where all our friends were, and they would hype it up and then go completely left. But it still ended up going completely left, and we ended up fighting.
Yeah, it was pretty bad. It started right here. I was about to use the bathroom, and she stopped me from using the bathroom
Because I wanted to talk to her, and it, like at first it started off well, but because my friend Cameron was like right there, because we were in the same class, I think him standing there just made it like
seem like that you were coming.
Yeah, like I was coming, because he was like, "Don't do that," and then I'm like, "What are you talking? I'm not doing anything." Like, it just made it sound like I was coming to fight her. So it went from here, like, out
Like
here.
came from here and
And this
like
girl
fell.
ran out of the bathroom stall and was like, "Why are y'all fighting?" and da da da. And she like darted out the bathroom. She was in my class. So
And then we like came. I don't know how we got out here, but it came like all over here.
Cameron had closed the door before the girl ran out, and when she ran out, she opened the door and left it open. Because I guess he didn't want us to get in trouble because there's cameras out here and no cameras in there. So
Yeah.
nobody would have known.
If we were fighting. So.
Yeah.
But I don't even know if we were still fighting if we would have broken up.
True.
Well, just go like, it went here, and then it went there.
And then it went here, like we were on the ground for a minute. And then over here. And then we came
Back
back
over
over
here.
here. And then all the way over here into the classroom. And then we came over
So we went to the school, and let me back up a little bit. This fight happened almost at the very end of last school year. We got the referral late in the summer. So the second day of school, this new school year, we were there to meet with these girls. And so we did what we always do. We met with one of them privately, me and two of my students. And we give them a chance to understand who we are, how we might be able to meet their needs, give them a chance to talk about what happened and why, as much as they know, because they never have the whole story. The other side has the rest of the story. Give them a chance to help us understand how they've been affected by this and how others have been affected by it. And then to start talking about what needs to be done to make things right and to get back to a good place with each other. Have that meeting with both sides privately to begin with. During those meetings, we also talk a lot about who they are, what are they dealing with at home, what are their aspirations for the future. And as it turns out, both of these young ladies have dealt with some significant and difficult issues outside of school and their own private lives. As mediators, we began to understand that they had a lot of things in common that they did not understand they had in common. And so when we brought them together, we were able to lead them in a conversation not only about what had happened and why it had happened and how they'd been affected and what they wanted to do about it, but who are they as human beings? And they began to realize they had an awful lot in common. One of the beautiful things that happened in mediation was that Sienna was working at McDonald's at the time, and Tori was looking for a job. And Sienna, after they had reconciled, Sienna said, "Why don't I put in a good word for you at McDonald's and see if we can get you a job?" And we said, "Working with you?" She said, "Yeah, that'd be cool." Now that never happened because Sienna wound up going somewhere else that was better for her. But she still is offering to help Tori get a job and work together with her.
We met with Mr. Powell. Tori met with Mr. Powell first. Then I met with him. And it was good. We were separated each time. Like, we met twice separately. Right. Yeah, we met twice separately. And the third time, like right after my second meeting, me and her had to meet together. And I was just like, and to ask him, I was like, oh my gosh, like, do I really have to do this? I don't want to do this. And then it turned out really good.
We had to sit directly across from each other, which was pretty like hard because it was just like so much tension, and it was like I was trying to, like, while I was talking to her, I was trying to give direct contact, but then at the same time it was just like,
you don't want to stare somebody in the face, like, while you're talking to them, especially if you're not like on good terms. Yeah, so it was like, I was like, when we were talking, we would look at each other and then we would like look away, like just like
we had to explain a lot about why we were upset, what happened, and
yeah, had to give my side of how I viewed it, and then she had to give her side of how she viewed it, and yeah, we ended up apologizing, and I told Mr. Powell that I was not going to like tell personal business and cry and everything else, and it ended up happening anyway, and it just, yeah, I think that's like what made it even like
more
like worked out even better, because we were going through the same things and we wouldn't have ever known that if it wasn't for that. So yeah, we were like more alike than we at that time.
To me, the most important work that we do in our process is to help them make that human connection, especially in the conflict resolution, which is mainly what we're doing in school cases. We're going in to help to resolve conflict so that the kids don't have the suspensions, so that they don't have the petitions into the court system, and so that they're not disrupting the educational day in the school year. They do make human connections, and when you can help that happen, that's when you see the conflict begin to fall away. It becomes the least important thing that's in the room, and the most important thing becomes the human beings that are now making that human connection. It's critically important, I think, in the mediation process. Yeah, when we're talking about the school to prison pipeline, this is exactly what we're talking about. These kids had an altercation at school. They were arrested, sent into the criminal justice system. So, school to prison pipeline. If this program did not exist, they would have stayed in the criminal justice system, and the system would have dealt with them in some way. It might have wound up in a conviction that would have been a permanent part of their record. I hope that what would have happened would be that the court would have seen fit to put them in a diversion program to let them do some community service and whatever else is in the program, and then actually dismiss the criminal charges, but we don't know what would have happened. What did happen was they were diverted away from the criminal justice system, and they were put into a mediation process that ultimately ended with them reconciling, with the school being satisfied with everything that happened, with them no longer causing any disruption in the school, and their charges being dismissed. So that's what happened. We reached in and we snatched them out of that system. And so we snatched them out of the school to prison pipeline. And I think that is significant. And I wish that every jurisdiction in the state and in the country had the ability to do that. When we talk about interruptions to the school to prison pipeline, I think that case is a great example of how we can interrupt that school to prison pipeline and begin to dismantle that school to prison pipeline.
I don't feel like we would, one wouldn't have started a dance team together.
Yeah.
And two, when did we start? Oh, that's it, actually. Same day that we sat down and talked to each other, we had English together, and we sat next to each other in English, and we were just talking, because we're both senior. Yeah, we were both just like talking about senior year and how we wanted to be everything, and we were like, yeah, we want to perform for Queen of Hearts, which is bigger than homecoming at our school. And like we both danced, so we were just like, yeah, we'll just dance together for Queen of Hearts. It was the same day as the mediation, which was like ironic, and then yeah, it just went from there. Like we were with pretty much with each other every day.
It appears to be successful. I think the two girls have benefited from the program. They seem to be friends now. I don't know if they're hanging out all the time or not. You could ask them, but I think they do stay in communication with each other, and they are friendly with each other.
So over the course of our academic year, me and my students will do about 80 of these cases in Wake County schools. We'll receive another 20 or 30 referrals from the juvenile court in Wake County. And this is a pretty common result. When people elect, because it is a voluntary, restorative justice practices always need to be voluntary. When they elect to enter into this safe space that we can create for them, they usually have a result that resembles what you have seen in this case. I'm going to keep us on time, Betsy, so I'm not going to take questions right now, but I'm going to be here the rest of the day, happy to talk to you at any time at our breaks and so forth. I want to share one more thing with you before I leave, and this is a restorative concept. When we do our restorative circles, we start with some sort of opening ceremony that marks our time together and marks it as sacred space. And then we do a closing ceremony that marks our time that we are about to walk out of that sacred space as we're about to walk out of. This is not my presentation, it's not a sacred space, but it's just a good model for you as far as restorative practices are concerned. We also do very high level facilitation. We have 3 or 4 murder cases open right now and adult cases where victims have come to us. and have a desire to receive information from offenders and dialogue and maybe even face-to-face meetings, and we try to help them with that. We also do restorative circles in schools, and we do restorative circles in prison. And we were doing a circle in prison last semester, and the guys that are in prison, and this is maximum security, so they have a minimum of 20 years, and some of them are never going to get out. But one of the greatest desires is to be able to do something that has a positive effect outside of the prison walls. We were leaving the circle this particular day, and we were going to be leaving the prison and going to a middle school to do a restorative practices training for middle schoolers. And we said, you wanted to have some sort of influence outside of the prison walls. Is there some message you would like to send to these middle schoolers? And so they wrote some things down. I want to share 3 of those with you. This is from Vince. It says, the road that led me to this hole I'm in started with misbehaving in school. Whatever situations there may be at home or in our families, this is the perfect time for us to decide not to allow these situations to influence us to live lives that end up or detour through prison. William says, you have a precious gift, that of freedom. Don't waste your life as I have. And William is one of those who will never get out. Grab hold of your gift and use it to make positive things happen in life. You can't do this by focusing on the negative things in your life, but find the positive in everything and hold to this. Life is too short to waste 1 minute. And Dylan says, and Dylan is coming from a point where he was telling a life story as a child and finding a deer stand in the woods, and he and his brother climbed up in it, and he said the world looks different from up there. So get a different perspective sometimes. He says, these are some of the best years of your life. Cherish the people you meet. You never know who you'll need later. Taking the time to listen first and talk later can do a world of good. Sometimes you have to take the time to see the world from someone else's viewpoint. And we shared that with the kids, and at their break, without being prompted, they wrote notes back. And we took these notes back to the prison the next time we met with them and shared them with the guys. Dear inmates, and I don't really like that word, but anyway, 7th grader, dear inmates, I'd like to thank you for your encouraging words. I'd also like to acknowledge you for your hard work and stability. What you say doesn't go in one ear and out the other. It really touches my heart and seeps into my brain. Even though I don't know you, I have accepted you and who you are. Everyone makes mistakes, and everyone deserves a second chance. Thank you so much for your time. This encouragement is great because it has now been offered to me as a factor to help me achieve and get through life. Stay strong because your freedom will come one day, if it hasn't already. Maybe not physically, but mentally. And that's from Caitlin. Have hope. We all make mistakes since we are all human beings. There is no time for past regrets. Live in the present and be happy. Try not to let the past bring you down. You are perfect in your own way. Be proud. That's Naomi. Everyone feels alone sometimes, but even if you don't have any family or friends, there is always someone who cares for you. That's Sydney. Always there is a way to change or do better, and that's Emma. One of my missions is to help others begin restorative practices programs in all parts of this great land that we live in. I have provided all of our rules, forms, memorandum of understanding, a resource list to Betsy. She has those in digital form. She is happy to share those with you. My contact information is on there. You can find me on the Campbell Law School website. I'm always happy for you to send me an email, and I'll help you any way I can. Thanks for having me, Betsy. This has been great.
Thank you, John. I feel restored. How about you guys? I feel really good about that. Now we have Miriam Haskell. She's an attorney at Southern Poverty Law Center in Miami, and she is going to deal with, hopefully, the present and future state of direct file in Florida, and then that will be followed by a panel discussion.
Thank you.
Hello, good morning. Thank you all for having me here. I'm really looking forward to introducing you to some of the issues surrounding direct file in Florida, and then speaking with a few of the players who are in this room and involved in this issue on a day-to-day basis. I am a lawyer with Florida's Southern Poverty Law Office. We are based in Montgomery, Alabama, and focus on a variety of issues, but our Florida office is specifically tasked with working on juvenile justice. So what that means is we focus entirely on education and incarceration. And I personally focus on the incarceration side. So if folks have education questions, I'm going to have to defer to other people in the room. Prior to working at SPLC, I worked as a public defender in Miami, and that really had a significant impact on my decision to go into juvenile justice work. I found the juvenile court cases that I handle to be some of the most challenging and the most rewarding. So when I got the opportunity to do systemic work at the Southern Poverty Law Center, I jumped on that. So today I'm going to talk about the current state of direct file. I'm probably going to use the term direct file and adult transfer interchangeably. That's because the majority of kids who get sent to the adult system in Florida are direct filed, a handful of them are indicted, but we're talking about the same thing, essentially, sending kids from the juvenile court system to the adult system. So continuing with today's theme of frustration, I will give you a preview and tell you that the current state of direct file in Florida is bleak, but hopeful. So Florida sends more children to the adult system than any state in the country. Over the last 5 years, more than 10,000 kids in Florida have had their cases sent to the adult courts. I'm going to start by talking about some of the numbers and the data that we have available. The data that's in this presentation is from the 2013 to 2014 fiscal year, so it's actually pretty new. I mean, it's as good as we've got, but it is referring to about a year to a year and a half ago. So that year, Florida transferred 1,322 youth to the adult court system. Now those numbers are tracked by individual kid. So if a child was transferred more than once in that year, they're only counted once here. But they could have, been transferred in June for one case, gotten that case resolved, and then a few months later picked up another case that was sent to adult court. They're only counted once. But even with that qualifier, we still have 1,322 kids who went to the adult system last year. The data in this presentation is really great and easy to access. It is all tracked by Florida's Department of Juvenile Justice, and it's available on their website in what's called the Delinquency Profile. We at SPLC have done a little rearranging of the data to make it more accessible, but there's some really good stuff there that I encourage you to dig around in. So the numbers demonstrate, and this is something the dean hit on or previewed with his discussion of the child welfare system, but the numbers demonstrate that geography matters. Geography impacts the likelihood of a child being sent to the adult system. The other thing that impacts the likelihood is race. And what we find in these numbers is that the likelihood that you're going to be sent to the adult system is greatly increased if you're Black or Hispanic. All right, so this is an overall look at the state of Florida. As you can see, white children aged 10 to 17 make up 47% of the population, and yet they only make up 24% of those who are direct filed. The vast majority of kids who are direct filed are Black or Hispanic. This is something that I continuously find shocking. When you break cases that get sent to adult court down by violent or nonviolent offenses, nonviolent offenses are far more likely, or I'm sorry, I shouldn't say far more likely. The majority of cases that are sent to adult court from juvenile court are for nonviolent offenses. So what that means is that property crimes are going to adult court. The violent offenses listed here are things like robbery, sexual offenses, even resisting an arrest with violence, sexual battery, kidnapping, murder. those are only 40% of the cases that are sent to adult court. So this notion that we're sending the most serious juvenile offenses to be tried in adult court is false. All right, so this slide is actually a little dated, or this number is a little dated, and what it shows is what of an outlier Florida has been over the years. It's a little small, but Florida is at the top of this this chart, and then other states listed after it: Connecticut, North Carolina, New York, Arizona, Texas. There are 393 youth in Florida, adult prisons and jails in 2009, significantly higher than the other states. I ran the numbers a couple days ago for the kids who are under 18 and in the Department of Corrections. So this stat is for prisons and jails. Among the kids who are under 18 and in the prisons in Florida right now, it's looking at about 120. 120 kids of all the children in Florida may seem like a small number to some of you all, but those are only the kids that, I saw someone shaking her head in the back. So yes, it is not a small number. But what is important to remember is that those are the kids who got transferred to the adult system, either pled, resolved their case, went to trial and were found guilty, and then went to prison. What it doesn't capture is the greater impact of the direct file system. So something that I think Public Defender Rob Mason probably deals with all the time is kids who are threatened with direct file while in juvenile courts and are forced or feel forced to take a plea, often before they even get full discovery in their case, have time to litigate their case, have time to think this out. The mere threat of going through direct file, getting that adult conviction, adult probation, worst case scenario, adult prison, keeps kids facing these extreme consequences in juvenile court that could lead to incarceration. I mean, juvenile programs are no joke either. All right, so far we've talked about statewide numbers, but I want to look also at local numbers. So here, Duval County. Last year, 70 kids were sent to the adult court. Again, in terms of race, Black children aged 10 to 17 in Duval County make up 39% of the population, and yet they were 83% of kids who were direct filed in Duval County last year. Miami-Dade, we had 81 cases in Miami-Dade, where I'm from, sent to adult court last year. Broward County, 136. Now these numbers are particularly significant. I'm going to go back and forth here because Miami-Dade has a population of 250,000 kids aged 10 to 17. 250,000. So of those 250,000 kids aged 10 to 17, 81 were direct filed. Broward County has a significantly lower population with 179,000 kids compared to the 250,000, and yet they're sending 136 kids to the adult system. So this is what I think the dean was hitting on earlier, this accident of geography. We like to call it justice by geography, or perhaps injustice by geography, but what children are facing often just varies when they cross a border. I mean, these counties are right next to each other. So among those youth in Miami-Dade County, 85% are Black or Hispanic, age 10 to 17, and yet they are 100% of the kids who were direct filed last year. 100% of the kids who were direct filed in Miami-Dade County were people of color. Broward County, similar numbers. White children make up 32% of kids in Broward County and are only 10% of those direct filed. Palm Beach County, 139 kids direct filed in Palm Beach County last year. We're seeing the same thing, right? 44% of kids aged 10 to 17 in Palm Beach County are white, and yet only 12% of kids direct filed are white. Black children make up 25% of the population, 70% of those direct filed. Hillsborough County, 101 cases of kids transferred. Same numbers. I know this is going to get, I hope this is no surprise for people, but I mean, I think these numbers are are stark, and they're something that we need to address, and I hope it's something that we can talk about on our panel. Hillsborough County, 44% of kids aged 10 to 17 are white, only 14% of those direct filed. Orange County, 70 direct file cases. And you'll see, I haven't announced this number, but I hope you guys are reading it. I mean, so below the 70 is at 2.7% of all disposed juvenile cases. So what we mean there for the, what we mean there are cases that are resolved in juvenile court or sent to adult court. So those kids are, you know, committed, probation, residential programs, received diversion. So that number is taking into account the resolutions in juvenile court, and of those, 2.7% in Orange County were kids who were sent to adult court. So that's how their case was resolved in juvenile court. So Orange County's number is actually slightly lower than other counties where the numbers were closer to 3, 5, 6%. These numbers are just as stark, though, if not more. In Orange County, white children make up 36% of the population, but only 4% of those direct filed. Black or Hispanic children are 94% of those direct filed. There are only a couple more of these, but there's equally significant. Pinellas County, 67 kids direct filed. Same thing, 64% white population, 34% of kids transferred to adult court. Polk County. I spent a lot of time in Polk County. We've been litigating a case there against the adult jail for the last 3 or 4 years, and so I've had the privilege of seeing a lot of these problems really play out for kids there. 71 kids in the year 2013 to 14 were direct filed. I've probably talked with all of them. Polk County, the numbers are equally stark. 77% of the youth aged 10 to 17 who are direct filed are Black or Hispanic. Now this is significant when you think about population as well. Polk County and Orange County are neighbors. Orange County is just to the northeast of Polk County. Polk County had, in this year, 64,000 kids aged 10 to 17, compared to Orange County, which had 132,000 kids. So Orange County had more than twice the number of kids in this population, and yet they direct filed the same amount. So once again, this justice by geography just varying so significantly, double the rate, but based on just crossing a border. All right, so I think the takeaway from that is pretty obvious. You know, Florida's system is not fair or just, and it varies within a community based on race and privilege, and then it varies within the state based on location or geography. One thing that we advocates for kids have been hearing in recent years is that the situation is improving, that the direct file numbers are going down. And so these next few slides are just taken directly from DJJ's website and this delinquency profile. And what they show is that in some places, go Hillsborough County, the direct file is going down. So last year, 101 kids were direct filed, compared to 177 the year before. So something's going on there. Same is true in Dade County, my home county. Almost half the kids from the year before. So 163 kids direct filed 2012, 2013. The last year, only 81 kids direct filed. That's good news for those counties, but folks would have you believe that this is happening everywhere, and it's simply not the case. Once again, this justice by geography is enormous. Broward County, 136 kids transferred last year compared to 107 the year before. Lee County, 33 kids, relatively small number, small rural county. 33 kids transferred compared to 15 the year before, so that's double the number. Palm Beach County, 139 kids transferred compared to 114 the year before. So these numbers are going up in a lot of places. Leon County, Tallahassee, our capital, 29 kids compared to 26 the year before. That number may not seem like a significant jump, a difference of 3, but we're seeing essentially a steady increase from, over the last 5 years. I'm not exactly sure what happened in Leon County in 2010, but there's obviously a jump there. All right, so again, You know, a child's experience is going to vary significantly based on where they are in the state. And one of the things that we've been talking about at SPLC and around the state is, you know, what can we do about this? What can we do to make the system more fair and more just and simply better? And let's be honest, I mean, from our perspective, better means reducing the number of kids who go there, period. I mean, we want the experience of kids there to be fair, we want there to be justice, but really, we don't want any kids to go to the adult system. We believe that the juvenile justice system was set up to serve children and to rehabilitate them, and that they can be served there. But in the meantime, we have a few ideas on how to improve the system. This list is by no means exhaustive, and hopefully we can talk about some of these ideas in our panel next. But you know, one big idea is to reinsert judges into the process. Right now, discretion lies strictly with the state attorneys as to whether to send kids to the adult system. We want to see judges reinserted into the process, and for that process to have certain standards and have certain factors be considered. So things like a child's, some of these are obvious, you know, things like a child's juvenile delinquency history, mental health background, whether there have been attempts to serve them in other areas and those have failed, their role in the alleged crime, you know, were they an active participant, were they along for the ride? These are the sorts of factors that should be considered by judges. Another piece of this is to have those decisions made by judges reviewable on appeal, so that it's not just one stop, you move to adult court, you know, go directly to jail, do not pass go. Second option, or second idea, is to keep kids in juvenile detention facilities until they are convicted in adult court. So the statute as it's written now requires that kids be transferred directly to the adult jail upon being direct filed. That means that they're going to see a gap in services. You know, juvenile detention facilities vary widely around the state as well. They're not awesome places to hang out. They're not great to stay. But DJJ is making an effort to provide rehabilitative services, to provide an education that mirrors a regular school day. So we'd like to see kids who get direct filed be able to stay there so that they continue those services. What we see when they go to the adult jails, pending trial or pending resolution of their case, is that they're typically not receiving the education that they would be getting, the medical services that they would be getting, the rehabilitative support that they would be getting. Another suggestion is to set a minimum age for direct file, a higher minimum age. So, you know, 16 is an idea, so kids have to be older before they even face the possibility of adult court. You know, and this stands in contrast with what John was saying right before me, that in North Carolina, 16, you go directly to adult court. And what we want is for, you know, those kids who are 13, 14, 15 who are getting caught up in the system to be, you know, for there to be no choice for them to be served in juvenile court. Another suggestion is to make direct filing always discretionary and never mandatory. Right now, as it stands, certain offenses based on and certain ages, when combined, require mandatory direct filing. We'd like to eliminate the requirement that all related felony cases be transferred to adult court when one case is sent to adult court, so that cases that are hanging on in juvenile court can continue to do so. And to only allow direct filing on certain enumerated offenses. And, you know, going back to the third or fourth slide that showed that a lot of the cases that are getting direct filed are actually nonviolent, and that should never be happening. We should only be sending the most extreme cases to adult court, if any. So this is only a start, this list. I mean, ultimately, we'd like to see a system that services kids exclusively in juvenile court, but this is a place to begin. So why is this reform so important? I mean, I think that for some folks in the room, it's going to seem obvious, maybe not for others, but you know, an adult felony arrest or conviction can have enormous consequences, including on future education and employment opportunities. Kids held in adult jails are more likely to be held in isolation. We see this especially in small counties. So in Miami-Dade, in Broward, in Palm Beach, the jails have specific units where kids are held when they are direct filed. In smaller counties, kids end up in isolation. They end up alone in a medical unit where they don't see anyone except guards because of regulations that they be kept sight and sound separate from adults. So these jails are not equipped to service them and to keep them safe, and so they wind up being held in isolation. Those kids, going back to one of my suggestions, those kids could stay at the juvenile detention facility and receive those same services if we were able to change the law. As I mentioned, adult jails across the state are failing to provide children with the education that they require according to federal law. This is something that we see over and over and over again. I've talked to kids whose education services include someone from the Miami-Dade school system coming and sliding worksheets under their door in isolation for them to complete that day. Needless to say, those children are not completing those worksheets. So, and all of this is despite the fact that those kids who are in those adult jails could still receive juvenile sanctions. So they go through all this process and they are deprived of their education, they're deprived of rehabilitative services, they're held in isolation, and yet when their case is resolved, that judge in adult court could still send them to a DJJ program. They could still get those juvenile services, and yet they go through this period of utter deprivation. Now for those kids who go through the entire adult system and end up in what I believe is the worst case scenario, the prisons in Florida, I mean the dangers are even more extreme and they are more immediate in my opinion. So children housed in adult facilities are 36 times more likely to kill themselves than those held in juvenile detention facilities. Kids in adult facilities are 34 more times likely than kids in juvenile facilities to commit further offenses. So, no surprise there, the adult prisons are not teaching our children. I spend a lot of my time, and I spent a lot of my time before today, this week, driving around Florida, meeting kids in these prisons. I've met kids all over the state, and I can tell you, I mean, it is both the hardest and the best part of my job. And I know a lot of the practitioners in this room and some of the lucky law students have had similar experiences. But I'm here to tell you that these prison facilities are absolutely brutal, and what we are sending kids to, beginning with direct filing them in adult court, has extreme consequences. I mean, I've met with kids in the adult prison system who have had their faces sliced with illicit blades, who've spent more than 100 days in isolation cells in these prisons, who are taken out for recreation from those cells very, very sporadically, not even once a week, and that recreation includes being placed in shackles in a cage in the sunlight alone. These kids have gone without food because guards are punishing them. They've been pepper sprayed through food flaps in their cells when they're not responding to guards' orders to do things like return a food tray through the slot. They've had their families threatened. They've had guards be physically abusive. They've been denied psychiatric medication that they relied on at their previous facility and had a record of taking, only to spiral downward and get involved in disciplinary issues. So the situation is absolutely inhumane in these facilities, and it all starts with sending kids to adult court. And so I think we need to think really hard in the coming years about changing this, and that we all can play a part in making sure we do better. And I hope that we can talk more about it with our panelists. Thank you.
Oh, that's just not right.
Do you want to do one and one?
You guys in the back?
gonna be able to see everybody.
It looks good from back here.
Okay, Rob's not going to be happy no matter what we do. So you've met Miriam. We have Mark Leal at the end, Managing Director of 4th Judicial Circuit, State Attorney's Office. Julie Taylor, next to him, the Director of County Juvenile Court, Office of the State Attorney. And Rob Mason, who is the Juvenile Justice 4th Judicial District Public Defender Director. And Miriam. So, in preparation for this, I came across an article that was published, or a report that was published by the Human Rights Watch about less than a year ago that quoted Florida had moved 12,000 children from juvenile to adult system in the past 5 years. More than half have been charged with nonviolent crimes. 98% of the children who ended up in the adult court do so as a result of this direct file statute, which came about in '94. I really was not that familiar with direct file. I thought I was. Florida has the highest rate of direct file of any other state, with 165 per 100,000 juveniles, twice as high as the next highest state, which I believe was Oregon, 3 times higher than any of the other states. Since this report a year ago, Miriam, do you think the numbers have come down at all?
So the numbers that I showed, the blue charts towards the end that demonstrated that certain counties had seen increases and other counties had seen decreases. When you run those numbers for Florida as a whole, they do show a slight decrease, and I'm not exactly, I can't recall, Rob, you might know, like what the decrease has been. But our concern is that even if there is an overall statewide decrease, there are certain counties where there are significant increases.
Julie, do you know if Duval's numbers have decreased in the last year?
Well, generally speaking, our caseloads have decreased. So yes, the numbers have decreased across the board. So in other words, when I started as the juvenile division chief about 6 years ago, it was twice the number of cases that we were opening than we're opening now. Generally speaking, year to year, we direct file about 2% of that total number of cases. We divert, just to give you an example of something else we do, we divert about 30%. So we get many more kids out of the system than we actually direct file.
So you're saying that our numbers have decreased due to diversion?
No, I'm saying diversion is a part of the process, and we do it a lot more than we direct file.
In preparing for this, Rob, I came upon some research talking about the reverse waiver that apparently some states have. Can you speak to that, what this reverse waiver is?
But first I want to give a thank you to Florida Coastal, and specifically to Betsy Dobbins, and for providing water instead of Diet Coke, because when I was listening to Miriam, I put half of it on my pants. Well, let's get an understanding, and I want to go to the numbers some.
Okay.
Because first, the direct files in this circuit are dramatically down. And they're down both because of less juvenile crime, and they're also down as a percentage. Now, Ms. Corey's office is well known for direct file. Part of that's frankly unfair, and I always like to point this out in a public forum. When the Legal Needs of Children Committee, when the main report came out in 2002, it specifically referenced the 4th Judicial Circuit and for many years people pointed to the Fourth Judicial Circuit. Our numbers have been middle of the road in this circuit for a number of years. The overall crime is so dramatically down, but the percentage of children that are direct filed really isn't changing much when you look at the big picture. In the sense, I try to look at children that are either direct filed, a maximum risk residential, high risk residential, or moderate risk, although as of July 1st we don't have that. And the direct files are down, but the percentage, when you add up all those cases and say, okay, they're going to either go to adult court or the 3 highest juvenile facilities, it's about around 36 to 39% of those cases. That hasn't changed. So the rate has not gone down statewide, although the rate in this circuit has gone down, and that's a credit to Mark Khalil, that's a credit to Julie Taylor and to their office.
That's encouraging to hear that the rate has gone down here. Can either of you address why the rate statewide has not gone down?
Well, I mean, I think it's very difficult to look at it from statewide because every elected state attorney has a different vantage point that they're looking at this problem with, and they have different philosophies as to what crimes or what defendants or what their criteria are when it comes to a discretionary direct file case. And so it sometimes is difficult to compare Duval County to Dade County because there's a difference between Ms. Rundle and Ms. Corey. And you're going to notice those differences based upon the different philosophies of the elected state officials in those areas.
And keep in mind, those officials are required to file with the governor's office their criteria for direct file. We choose to follow the statute pretty strictly. And we even negotiate in some cases to work around the mandatory direct file that's required in some cases. Some offices might be more strict, some might be less strict. It really is an office-to-office kind of policy.
I have a question. I have 2 questions. When you're talking about direct file, and the numbers, are you distinguishing between the mandatory, because you mentioned the statute, that's important, versus the discretionary? So I'm more concerned with that discretionary. And I agree with you that the mandatory is important because we do have a direct file advocate, and our state attorney sometimes let her negotiate the charge, and that will impact that mandatory section.
We do that all the time, to be quite honest. I was just saying to Mark, as an example, we will find where a juvenile, for example, goes into an abandoned house and burns it down. That is technically a first-degree arson, which is a mandatory direct file. We have negotiated lesser charges to be filed just for the purpose of keeping them out of adult court, because very often you might find that child has no criminal history and there's no need to send them to adult court. But I think that's an important distinction, is the mandatory versus the discretionary, and I think that's probably Mr. Khalil's point is, you know, you have to go from office to office and see how do they treat that discretionary versus that mandatory where we really don't have a choice. The discretionary is a very wide swing, in my opinion, and it really comes down to the philosophy of the office. But I would say I don't think statistics differentiate between discretionary and mandatory.
No, I don't think they
That's
are
my opinion.
I do have to give Rob a chance to respond here before you jump to
Two points. One is because I forgot to answer the prior question about the reverse waiver.
Please do.
What we need to realize is there's only 15 states that have this direct file where the prosecutors have this unfettered discretion. Of those 15 states, Florida is one of 3 that doesn't have what we call reverse waiver, which means if the prosecutors make a decision to direct file, you get to challenge that at the adult level and convince the adult judge before, pre-adjudication, this case should be back in juvenile. We're one of 3 states that don't have that, so we are an outlier. The other thing is, in terms of mandatory and discretionary direct file, even the mandatory direct file in the statute says it's not mandatory and that you don't actually have to do it. The prosecutors have the ability not to direct file on a mandatory direct file. So I don't believe there really is a mandatory direct file, and Ms. Taylor is correct that if you look at the DJJ website, you can't distinguish between cases that fell under that mandatory direct file. I think it would be helpful, and I'm sure it would be a higher percentage, because those are more serious cases, or combination of the child's age and the prior offenses.
Miriam, what are some of the encouraging programs you're seeing for rehabilitation in Florida, or are you seeing any?
You know, I actually, Rob, do you have an answer to that? I mean, you see more kids on a day-to-day basis. Yeah, anyway, in the DJJ stuff. I mean, I'm focusing more on kids where they ended up a lot of times in the adult.
Okay, I'm open. I would love to hear.
Betsy mentioned diversion. Diversion is a huge part of what we do, and I don't know that people realize it, because at the end of the day, we're prosecutors. We go to court to try cases. But like I said, generally speaking, from year to year, we divert about 30% of the juvenile cases that we open, and that's a huge percentage when you think about it. We have approximately 7 programs that we run just through my office to divert juveniles out of any system whatsoever. We get them out of the juvenile system, out of the adult system, and give them an opportunity to feel a consequence, so to speak, and to hopefully deter them from coming back. So diversion is one thing that we think is extremely important, that we try to contribute to get a juvenile out of the court system, hopefully for the rest of their life. Hopefully.
You know, and one point that I think is important to remember from our perspective is that we believe that most of those kids who end up taking diversion never should have been caught up in the system in the first place. And so those are kids that could have been resolved with a civil citation in certain communities, could never have been arrested, could have been handled in a school disciplinary proceeding, or maybe even could have, but never should have even made it. So, I really think that this panel is about, or this conversation is about sort of the most extreme situation, or what should be the most extreme situation, which is direct file, and comparing kids who are eligible for diversion, which often in certain communities requires to be a first-time offense, it'd be an extremely minor offense, and then kids who are facing direct file is really apples and oranges.
Good point. Good point.
I have a question. You guys, I would like to hear from the prosecutors, give you guys an opportunity to talk about how direct file functions here in Jacksonville, some of the decision-making process and weighing that your office does in determining who to file and who not to, and those discretionary instances.
And I'll let Julie start, because that's where it all begins in our office.
Right. We have a division chief and 3 attorneys who work in juvenile court. When they find a case that they feel should be reviewed for direct file, and that doesn't mean actually direct filing, but just reviewed for direct file, the attorney in juvenile court puts together all of the information about that case and all of the information about that juvenile, including any mitigation that we might receive from the juvenile's attorney. They then provide that information to my division chief in juvenile court, who reviews it and either says, no, we're not going to review it any further, or yes, I think it deserves more of a review. That information then goes to myself. I'm the director of juvenile in county court, and it also goes to a division chief in circuit court who works underneath Mark. We then review that collaboratively. So there are at least 3 of us who are reviewing that case initially as it goes through that direct file procedure. We very often go to Mark. We very often go to Ms. Corey. We very often confer with law enforcement to try to make the best decision that we can make about whether a case is appropriate for direct file. It is far from being haphazard in any way. These phrases that are used about threatening juveniles with direct file is very frustrating to me, because We do inform juveniles that their case is being reviewed, because the alternative is that they don't know at all. So what would be better? For us not to tell them and just to show up one day in court with a warrant for their arrest to go to adult court? Or is it better to let them know that that case is going through that process so that they can be a part of that process? That is what we seek to do, is to try to get everyone involved. Ms. Corey herself has met with juveniles and their parents when they're going through that direct file process so they can be a part of it. But obviously there are some cases where we think that the direct file is appropriate, and that's when it goes to Mr. Cleland.
And there are times when we have a disagreement amongst ourselves. Oftentimes there'll be a case that's sent to consideration for direct filing, and our circuit division chief says, well, I'm not sure if this is totally appropriate. And that's usually where I get involved, where I'll step in and mitigate that, or mediate that situation and make a determination or break the tie, as it may be, when it comes to whether or not this case should or should not go to adult court. But most importantly, we have appellate review and a location where Mr. Mason or any of his lawyers can then seek out and appeal the decision to Ms. Taylor, then to me, and then ultimately to Ms. Corey, which I think has happened on a number of occasions where Ms. Corey has personally intervened and made the decision as to whether or not this is a direct file appropriate case or not, when there may be even disagreement amongst Ms. Taylor and I as to what the appropriate outcome in that case should be. So there's a lot of thought put to this, and it's not a haphazard type of decision that we make. Most of the time, when we are making this decision to direct file, it's because there are either such serious offenses that have been committed, or there is such a documented track record of recidivism with this particular individual that we feel this is the only option that really can make a difference at this point in time.
Rob, can you comment about the appellate review of that process?
Well, I mean, it's a review in their office. It's not necessarily an independent review, but we appreciate the fact that they allow us to bring additional challenges if we think that's appropriate.
I have a, oh, I'm sorry, go ahead.
Sir,
I
go
have
ahead.
a follow-up question. What's the percentage of the kids in the system, the juveniles that are arrested, that are reviewed for direct file?
Just reviewed in general versus actually direct file?
Yes, because you're telling them
Right.
this is when you have to inform them
Right.
that direct file is, possibly being considered.
Mhm.
So, what's that number?
I don't know that we have a way of tracking that, to be quite honest with you, because there's nothing that's filed in court, there's nothing that happens that would trigger the ability to track that kind of statistic, but based upon the number of reviews that I get versus the number that we actually approve for direct file, I mean, it's certainly at least 3 to 4 times the amount. We don't direct file nearly as many as we review, and very often we review it based upon general criteria such as a firearm being involved. Ms. Corey has always felt that when a juvenile uses a firearm, it's a very extreme circumstance, so we tend to review those, but quite frankly, we don't direct file all of those, even though they involve a firearm, and we consider those to be the most serious offenses. So in armed burglary, for an example, where someone may go into a home and steal a firearm, that is something we review, but we don't necessarily direct file on a regular basis unless they have a significant criminal history that shows that prior juvenile efforts have not worked. So I wish I could give you a number, I can't, but I would say it's a significant number more than what we're actually direct filing.
So I don't practice criminal law, but my question is, with your example, would that be considered a violent crime if they're...
Well, I think you have to ask those who are giving you these statistics. Like, for example, I know pretty certainly that DJJ, for example, does not consider a home burglary a violent crime. But I would consider it a violent crime because a first-time offender in circuit court is looking at about a minimum of 21 months in prison for a home burglary. But yet, typically, when you see statistics like you've seen today, that is not considered a violent crime. And I would say that it is. I mean, think about you being at home in your bed and somebody breaking into your home. Would you consider that to be violent? I mean, Florida statutes certainly do, because you can get 21 months at a minimum in Florida State Prison for committing that crime. So I would say that that's violent. But that's where some of the breakdown occurs in these kind of discussions is, well, how do you define violent crime? And how do you define other things that, you know, that we talk about in these kind of discussions?
Yes. First of all, I'd like to thank Pam, Julie, Mark, Rob, Miriam. A two-part question. Number one is, what do you think the effect would be if Florida had a reverse waiver, or some, like most other states, 47 others, that were not among have some provision for judicial involvement in either challenging the direct file decision or involvement before the decision, meaning diluting the state's discretion, involving the judiciary in that decision to begin with. And then secondly, with the panels, in addition to what the impact would be, would you support Florida moving in that direction?
Well, I think the judicial review of the direct file process, one way to look at to see what kind of impact that may have is the number of cases where we do direct file where the judiciary felt it was inappropriate and sent it back with juvenile sanctions post transfer to adult court, because that's the one thing that I like to always emphasize in these type of discussions. We are merely choosing venue when we direct file an individual. We're not, other than when we indict an individual on a life offense, which mandates that they receive adult sanctions. We are not mandating the punishment. We're choosing the venue and expanding our possible outcomes and what's available as an outcome in this particular case. And Julie and Rob know the statistics probably better than I, but I would believe, based upon my involvement in review in circuit court here, a very small percentage of cases that have been direct filed upon, the judges are imposing juvenile sanctions, which means that the judges are confirming at that point in time the state's decision to treat this individual as an adult because they're imposing adult sanctions. And so, at least here in Duval County, I can't speak to date, I can't speak to other jurisdictions, I think the impact would be minimal because I see very, very few cases where we direct file a case and there's a plea to the court where then the court overrides our recommendation and imposes juvenile sanctions. So that would be sort of, I guess, a watermark to determine how that would affect our job here in Duval County, because that's about the same impact that you're looking at.
Thank you, Mark. Duval has one of the worst percentages in the state. If you go to adult court in Duval, you're getting adult sanctions 98% of the time. And the only time a judge gets to make a decision whether you should get juvenile sanctions or an adult sanctions is after you plead straight up to the court, exposing yourself to the maximum sentence, knowing that the prosecutors already want you in adult court, or after a trial. And if you read the Human Rights Watch report for the Florida direct file, which I encourage everybody to download and read, you see that most of these cases are trials. And it's like what Ms. Taylor pointed out with a burglary. If you have a burglary, bottom of the guidelines are 21 months Florida State Prison, maximum is 15 years. You know the prosecutor wants you in adult court, they put you in adult court. So, if the offer is 18 months Florida State Prison, that sounds better than 15 years. So you don't get the judge able to make a decision until there's been an adjudication by a plea or by a trial. And we know trials are very, very risky. When we had Marshall Levitt from the Juvenile Law Center at Jacksonville University last month, Pennsylvania is a state with direct file, but Pennsylvania also is a state with reverse waiver. And she stated that in Philadelphia, when they have their reverse waivers, 2/3 of the times they have a waiver hearing, the case gets sent back to juvenile court. So, Mr. Cabri, I think it would have a tremendous result in terms of how it would affect things in the state if there was a reverse waiver.
Well, and Rob, my only reaction to that is I think the fact that 98% of the time the judges impose adult sanctions is a credit to our decision-making process that Ms. Taylor and I have discussed, that we're choosing the right cases to send to adult court. and the judges are simply confirming that fact when they choose not to impose adult sanctions.
And keep in mind, the majority of what we direct file are armed robberies, aggravated batteries, carjackings. These are not grand thefts and possession of cocaine that's going to adult court. These are the most extreme cases that we deal with in juvenile court, and generally you're going to see defendants who are approaching the age of 18 in most circumstances.
And if I could just follow on that, just from your answers, and thank you for those, do I take it then that we could probably expect the state's attorneys to be opposed to such a move legislatively in Florida, and the public defenders to probably be supportive of it as far as judicial oversight or involvement or the reverse waiver process?
Well, I think that that decision-making process, and we have discussions on statewide level with the Florida Prosecuting Attorneys Association. We're going to meet and hear the differing opinions from the different 20 state attorneys from across the state and reach a consensus as to what our position is and what we feel best serves the system. I think there might be some disagreement amongst those 20 as to what the appropriate mechanism should be when it comes to how we legislatively attack this issue.
Thank you.
Yes, ma'am.
What is the time frame for your direct file review?
What is the time frame?
Yes.
It's different in every case. Very often, when we inform the defense that we're reviewing something for direct file, they need time to get information together to give us, which we call mitigation. So if they get it together in a week, it might be a couple weeks. If it takes them a month, it might take us 2 months. It depends on the entirety of the process. But I don't support a very quick and hasty decision. I know people want it to get done and want things to move along, but this is a very serious decision. So do direct file reviews sometimes take some time? Of course they do, because it's a very serious decision. But we do try to accommodate others, for example, the defense attorney who may want to gather information and provide it to us. So we're not going to make a decision without allowing them the opportunity to do that.
Okay, my next question is, what is your time frame? How long do you allow the public defender's office to respond to any offers that you guys make amongst each other?
Any offers?
Yes.
You mean if we're negotiating in terms of a...
Yes, correct.
Well, I mean, that's kind of up to them. I would hope that the attorneys are in constant communication. So in other words, if I'm talking to a defense attorney and they need time to meet with their client and their family, and they tell me they need at least a week to do that, then I'm going to give them that time. There's no reason why we shouldn't make the effort on both sides to accommodate each other so we can get the work done that we need to. But there's no strict time period on anything. Everything that we do is very fluid.
Yes, sir.
I'm not an attorney. That's not bad. But the demographics and the percentages that Marion showed, I interpret that there is an unbalance based on geographic, race, and whether the crime is violent or nonviolent. My question is, why? What is the reason that these numbers seem unbalanced? Is it the environment that the juveniles were raised in? Is it the system? Is it a bias? What is the reason that these numbers are unbalanced?
Well, if I can respond when it comes to the numbers, because the one thing that I saw when I was in the back, and it was the first time that I had seen the statistics and the pie charts that Marion put up there, and with all due respect to her presentation, I think you need a different comparison than simply the demographics. Because she was comparing the demographics of a particular location within the state and then the direct file ratio. You have to look at the demographics of individuals who are arrested for committing direct file eligible offenses, because those are the apples to apples comparison. You know, I don't know what those demographics are, but I imagine that those demographics of what are the racial makeups of individuals who are arrested for direct file eligible offenses differs from the general demographic makeups of that jurisdiction as well. And that may get more into the socioeconomic background and things of that nature. But I think it is a little misleading to just simply say there's this percentage of African Americans in Duval County and this percentage of African Americans are direct filed in Duval County, because you have to look at the percentages of the individuals who are arrested for the offenses that could subject them to this review that we go through on a daily basis. And so I think that's important. You have to look at the correct numbers before you make a comparison. Simply looking at a population is not going to give it to you, because guess what? If I looked at a population in this room of how many people here are seeking to become a lawyer, it's probably going to be pretty high, or those who are aspiring lawyers or lawyers today. But much like yourself, you say you're not a lawyer, you're going to be a small percentage in this population because of what we're looking at. You have to look at the people who are eligible to be direct filed and those demographics, and then look at it. There may be some disparities, but I need to see those numbers first.
You know, and I think that I appreciate Mark's point, and I think that comparison would also be valuable. But we can't ignore that, or we can't pretend that the decision to direct file, or this person, or that the system that we're in, you know, begins and ends when a kid is arrested. I mean, this is all part of a system that is unjust, and a system that frankly is biased and is racist. And the reality is that a lot of arrest decisions are made, you know, that also include state attorneys in the conversation. I mean, in many counties, state police officers are regularly consulting with state attorneys before they file particular charges on kids. So the state attorney's office is involved from the very beginning. So the state attorney's office may be involved in those initial decisions that then, you know, build the statistic or the population that Mark is discussing, this population of kids who are arrested for, you know, direct file eligible offenses. So it's not, we can't look simply at a snapshot. I mean, I think that the population data of a community actually says, you know, a good deal about this discrepancy.
If you're 16 and charged with a felony, you're direct file eligible. So this isn't some small class. And to piggyback on what Miriam said, we know statistically that there's no huge difference between drug usage between whites and African Americans. There's no difference. But in terms of who's arrested, who's prosecuted, who's in prison, who's in jail, there's a huge difference. So there, systemically, something is wrong. That's clear.
But without identifying a solution, I mean, without identifying the reason of these numbers, how can you come up with a solution? If you don't know the reason that something's happening, and we continue to do the same thing we've been doing, how can you expect different results?
And I think we have judges that say that, to be quite honest with you. We have one juvenile judge who's been doing this for a long time who says, if we keep doing the same thing, nothing is going to change. He thinks we should get into the neighborhoods and figure out why the arrest rates are what they are. We get cases because juveniles are arrested or adults are arrested. That's how they get to us. So you have to start on that very basic level of what's happening in these juveniles' homes, in their neighborhoods, in their schools, that is leading them to be arrested. That's where it all starts. And I don't know if that's necessarily your point, but I think you and I are on the same track, that that's where you have to start to address the problem.
I feel your frustration, sir, and I know that we have to break for lunch, and there is no way in the half a minute that we have left that we are going to answer any of the question that you just asked. So we are, thank you to all panelists. Great job.